Hello, hello. This is King Richard, and today we're going to talk about origin of trusts and how they work historically and how they work today, statutory versus non-statutory trusts. So the functional uh, DNA, so to speak, of a trust is that you have a piece of property and then you separate the legal control from the beneficiary or from the benefit that somebody gets. So you control a car and you let somebody use it. You have a bank account, you let somebody get the money from it. You have a property or a orchard or something like that, and somebody else is enjoying that benefit. That's the basic DNA of a trust. And this kind of relationship has existed for 4,000 years. So this new hack, I keep seeing these things on TikTok and Instagram, and they're showing a hack. For example, at Costco, you buy this big piece of meat and you cut it yourself. That's not a hack. That's just how we used to do it before we became lazy. So statutes did not create trusts. Trusts have existed for a very long time. It's 4,000 years old before any tax laws or corporate laws, even most modern nation countries, states, and courts have enforced trusts long before any legislation existed where uh, which were regarding trusts in general. So in ancient Mesopotamia, which is modern day Iraq, you go back for about 4,000 years. This should be BC, not BCE. Back then, people would have a property and they would entrust that property to somebody so that they could take care of their widows, family members, or their temple, or something like that, uh, while when they perished. And so the property was held by one person for the benefit of another. So original trust DNA. The arrangement was enforced purely by moral obligation, which technically became legal obligation because you would have, if you stole, basically that would be the legal obligation there, right? It's immoral to steal, and that was what became the legal obligation then. But the DNA is present, right? You have a separation of who controls it versus who benefits from it. During the Roman period, we had the first, we call it Fideicommissum, which is the fideus, meaning good faith. And so you would have a commission or um, a formalized paperwork, you would say, to transfer the property from one person to another, but that person would have work it for the benefit of another person, for the beneficiary. So it was initially enforced by honor, and then later, as it grew and it became apparent that some people weren't doing it by honor, Roman courts would step in. It created a legal obligation attached to that property. So if you had a orchard, let's say you live there with your family, but you're elderly and you're going to pass away, you give your property to somebody to take care of this property for you and your family. You're unable to work it anymore. You have a olive garden or a vineyard, and that person will take care of some of these properties. And when you pass away, this person would then have the duty to uh, bring this paperwork, this legal title, to your firstborn son or whoever you asked to take over. Now, if that person lived in if you were in Rome and that person lived in Milan or Napoli, that person would have to ride there, I'm guessing, or um, yeah, go there to deposit to give this son of yours or your heir this legal documentation. Of course, he could do whatever he wanted with that piece of paper. This piece of paper says you own the property, so you have to your enforced by honor, which is that you have this piece of paper. It says you own it. Whoever owns this paper owns the property. So that's how they got into Roman courts, right? Whoever owns this paper is the owner of this, and that was the original early days of modern trusting, so to speak. Then, as the Roman Empire was transitioning out or falling apart, early Christian Europe, the monks and the um, in the monasteries and the um, cloisters would have arrangements to hold property for orphans, the poor, or other religious purposes. So they would have something for um, a cemetery or something like that, where they would keep that control as one person keeping the control, the duty to control it for the benefit of other people. So you still had the mechanic there, where somebody owns it and somebody manages it for the benefit of somebody else. Then we put here the catalyst. It's really where England started. I always thought this is where trust started, but it wasn't. This was really the only the catalyst. These knights had their castles, and they would leave, not castles. Everyone in Europe has a castle, but people would leave to go on the crusades, and they could be gone for years, just like a regular war today. They could be gone for years, and nobody knew who would take over. Is Earl Jones dead or not? How would you know? So the inheritance rules in England were primogeniture, which means that the oldest son, the firstborn son, is the person that inherits your property. But what if you're 45 and your son is 22 and you both go to the Crusades? Who would inherit it now? And how would you know that somebody died? You would just have rumors. Somebody would return in 3 years, say, "Oh, I think I saw Earl Jones die over there in Constantinople." What, is that all we have? Just a rumor? So it became tricky. So how would they be able to leave their family behind for years? And how could they still be alive and benefit from their property? They might have horses, they might have orchards, might have trees, right, for building and wood. Who would take care of those? How would somebody be able to how could I keep my family alive while I was gone for several years? Who would pay the taxes? Who would not take advantage of this family? Which led into the solution that they invented, which was the use of. You would have the landowner who would convey the title to a friend. This word is fefi, fefi, a trusted friend, and he would get the use of the property for the beneficiaries, for your family. The title was given to your friend, and your family got the benefits of it. But that really depended on what agreement you had with your friend. Could he be persuaded by large bags of gold coins like we see in the cartoons? Maybe somebody would just come and say, "Hey, this piece of forest over here, the 200 acres, you could, give this part away from me, and I'll give you these coins here," which wouldn't benefit the family. Or could he, make sure that they got any money at all? Really depended on your friend. Is your friend really a really good friend? What if you have an agreement that any orchards that you have there, or trusts, and not trust, horses, you don't grow horses. What do? You breed horses. Okay. You get half the profits from all the breeding or all the orchards. But what if he only gives 10% to the family? What if he takes all the money? What would happen? So this led into the common law, which failed because all it said is, "Hey, this guy's got the title. He's the one that, he can do whatever he wants with it." And this became a problem. I mean, the only thing visible is when the old man dies, the first son gets it, and whoever has his piece of paper. That's the only thing that's visible, a legal title. If I promised you that you could have legal title of it or use of it, of my property, how can I enforce this? So under the eyes of law, that friend was the owner, Fefi. He was the owner. He could do whatever he wanted with it. So that became a problem as people returned home. And, I'm not going to give you this back. In fact, I'm going to kick your family off that little house over there. I own this property now. So that led betrayed beneficiaries and the returning knights to petition the king. We need some sort of conscience rule here, some way that you could say that you do it for the good. So the king created the chancery court. The chancery court really here is how the modern day trusts became what we use today. Beneficiaries were cheated, they petitioned the king, cases went to the court of chancery, which ruled on conscience. All right. So they would say that your moral duty became a legal duty. When you came to take over the, you got the use of the property, you have a legal duty to take care of the beneficiaries. This became equity and for a relationship which became enforced equity on top of you as the trustee as we see today. And that's how the today's trusts are seen, right? When you have a trustee and you have a beneficiary, the trustee's work is for the beneficiary, and you have a legal duty to do that. So the timeline we have is Mesopotamia in the very beginning. We held property for the benefit of others. The Roman law, we had the Fideicommissum. Crusades created the adoption of the use of property. Chancery courts were created and equity was enforced. The equity enforces duty. We have a duty to do this. And then today we have modern law, which creates statutes and regulates certain kinds of trusts. The principle is unchanged, though, right? We still have a piece of property. We separate the control from the benefit of this property. It could be a car, it could be a yacht club membership, it can be a sports car. The definition was true in Mesopotamia, it's true in Rome, true in England, and it's true today. Except the property we have today, of course, is crypto coins, stock options, insurance policies, etc., etc. So we get into statutory versus non-statutory trusts and understanding what works in court. So a trust is a relationship. It's not a product that we have. We have a property relationship, right? Which is the duty of the trustee, and then they work it for the beneficiary. It's enforced through equity. So we have this kinds of laws and rules in equity. It's governed by a fiduciary duty, which is that you have a duty to be fiscally responsible with the property. So you do not, or if you have a property and you fail to pay taxes on time, you fail to pay the water bill, electrical bill on time, and you keep getting late notices and late fees, you're not being a good trustee. You're failing your fiduciary duty. You're supposed to take care of the money as good as you can of the property. If you have a house, if you have a boat, and you don't take care of maintenance on that boat, on that car, on that house, or that property, you're not being a fiduciary, good fiduciary. And then eventually you will be judged, you may be judged on your behavior over time. So if you have a house that falls apart, a mansion, let's say, on a meadow overlooking 200 acres, and you don't take care of that property, you have a storm, a window breaks, a roof leaks, and you never take care of it, the building will fall apart. You might be siphoning off money. You might use some of this money for your own car, for your personal car that's not in the trust. And all those things, when if your beneficiaries ever take you to court, you being the trustee, or if you were taking someone to court because you're the beneficiary, and that property was not handled properly, taken care of properly, they're going to go look through the behavior that you had over time. Was this a just recent thing? Was it last storm from last week that the window broke? I just maybe I didn't know about it. But if this has several things over 2 years that you have not paid your bills on time, I can see this over time. I can see all these late fees. I can see this money not being handled properly. And this will hurt you if you're the trustee, or it will benefit for you if you're a beneficiary, that you can see that all these things are happening over time. So what is a statutory trust? Statutory trust exists because a statute authorizes it. There are specific laws created to create specific kinds of statutory trusts or special kinds of trusts. There are mandatory formation rules, and compliance is not optional. So when you design a specific trust, it's not a revocable or irrevocable trust that we know it. This trust exists for a specific purpose to handle pooled capital, for example, have several investors or business enterprises to create, right? We talked about the Toyota, they sell 6,000 cars a day. And those loans that people take with Toyota Financial get put into a trust. Now, many people can own that trust. You can put people into that trust. The Delaware Statutory Trust is a specific trust created for large real estate, for example. And you can have fractional ownership, like the vacation club. You own, let's say, a resort in Hawaii, and you can have 10,000 people that are part of that trust. They all own a little piece of the trust, and the trust is managed by a trustee or set of trustees that make sure that the trust is running properly, and they give the beneficiaries, money as the profits go on. But they have specific requirements. A REIT is a real estate investment trust. The Wyndham Hotels started as a REIT. They had all these buildings. They didn't have any way to operate them. Some were random hotels, some were Holiday Inns, some were any one of the Sheratons, the Marriotts, the Hiltons. If they only had one way that they could guarantee the outcome on these things, that's how they created the Wyndham Hotels, which later fell apart. You have the same thing for pensions and for asset protection trusts. These are special statutory trusts that exist. They have specific laws, exactly how they must be managed, exactly how they must be handled. You have compliance, you have quarterly or annual reports and that kind of stuff that have to be filed. So you have mandatory filing rules. You have non-optional or required compliance. If you fail these statutory requirements, your liability protection will fail. So you have to have these things, right? And then the purpose of this is for REITs, for pooled capital, and that kind of stuff when you're combining all the things together. But it's good because with all this compliance, you can trust that your money is being handled well because you have certain compliance that must be done. So what about a non-statutory trust? A trust existing under common law and equity, created by private instrument, not public statute. So there's nothing here that requires me in a certain way to create a trust. I can create a trust, a non-statutory trust. All it means is that there's no law to create this trust. Doesn't mean that it's outside the law. There's still laws that apply, right? You can't steal money. You can't avoid paying taxes. You actually have a trust. So if you create a revocable living trust and you put your house in it, you still have to abide by building codes. You still have to abide by uh, property taxes and all that kind of stuff. If it's in an HOA, you still need to mow your lawn. So it looks at real funding, which is a funding. A trust is when you move property into it. You can put money, you can put buildings, cars, and that kind of stuff. It's a genuine transfer, right? You've done your quit claim and everything. You have an independent trustee. That's why we sign documents separately. You sign as yourself, and then you sign as the trustee for our revocable living trust. If you have a irrevocable trust, you have to have somebody else do it for you. So the second path there is the non-statutory trust, more known as common law trusts, which is what we consider the original trust. That does not require state filing or government filing. It only exists because courts of equity enforce it. So you can take it to court. If somebody stole money, if the beneficiaries see that you've taken money out of it, then it still exists as a um, enforceable. You can still enforce laws behind it. So it's not like it exists outside the laws. So the common law trust exists because equity will enforce responsibility. So we have the two different trusts to compare. The statutory trust, statute created, they're standardized, filing is required. There's mechanical protections in it built into how it's driven, how the trust will manage it, and how it's compliance driven. You have to do annual reports or quarterly reports or monthly reports and so on to the federal government or state government. Then you have non-statutory trust, which equity created, which is that I do it personally, or me and Heidi create one together. It's customizable. There's no filing required. There's no behavioral protection. I can do, if I want to tear down my house and rebuild it, there's no problem there. I mean, it's going to cost me money, but and there's conduct driven. Conduct driven means that it's based on how you do it. So if you're stealing money from it, obviously your conduct is bad, and that's the bad conduct. So labels have no legal force. When you go to court, it doesn't matter how fancy your title is. You have a private, irrevocable, super foreign grantor, MAGA, Trump rules, super duper contract trust. It doesn't matter. The court doesn't care. You're not immune from the courts. You will always be, you could always be brought in front of the court. And the court will they will do a test to see how your trust is working. And it has 4 questions that it will ask always. Was property actually transferred into your trust? So when we get an EIN, it asks us, when was your trust funded? I can have a trust for 25 years and I moved my property into it in 2012, in August of 2012. But I don't need to have an EIN for it. Now, today, I want to get an EIN. It's going to ask, when did you put your property into it? When did you fund it? Oh, August 2012. You go back, that's when I put it in. That's when I put the house in. But I didn't need an EIN until now, because now you want to file things differently. Did control genuinely change? Is the second question that the courts will ask. Did you actually move property? Are you still doing it as yourself, or is the trustee actually filing for you? So now we can have our own trustee, or we are the trustee, right? That's fine, as long as it's signed as the trustee, right? If you when you sign any document, you put the TTEE at the end. Was that the trustee that signed it? Or did you forget? Now you're commingling, right? You're mixing the two together. Somebody else should be able to step in and do exactly what you've done in your revocable living trust, like we have. When you have an irrevocable trust, you usually let someone else handle it. And then they'll ask, is the trustee independent? It's tricky when it's ourselves. Now, usually we will have a small trust. So if you're being sued by your child, for example, when you're giving them they are the beneficiary of your trust, and the court asks, is the trustee independent? Well, maybe the trust has a lot of money, but you don't. Did you take money from the trust because you had needed money? And are the fiduciary duties honored? Is the final question. Did the trustee do what he was supposed to do with honor, right? Did you steal money? Did you gamble money away? All these questions will come in. It's a little tricky when we have our own trustee, a revocable living trust, because the independent trustee is technically it's us. So yes, but can you differentiate yourself from with that hat, the trustee hat versus your own personal hat? So every valid trust requires four elements. We know the settlor, the trustee, and the beneficiary, but we also need res. Res is property. If you don't put any property in it, if you don't fund your property, your trust, what do you have? You have nothing. You only have a trust once you've added stuff into it. You can create a trust. Many of us have created right here on this call, have created a trust, but we didn't put anything in it. Create a bank account. Now you have something. So your trust, there's nothing there to enforce. There's nothing there to say, hey, they haven't given me my stuff. I'm the beneficiary. I'm not getting anything. Well, there's nothing in it. So you don't technically have a trust until you've put property in it. That's called funding. Until you fund the trust, it technically doesn't exist or it doesn't do anything. It's like having an empty bottle of water. You're still gonna be thirsty. So a non-statutory trust does not mean that it is private from the law. It does not mean that it's sovereign or immune to courts. And it does not mean that it's outside taxation. Non-statutory trusts still handle all these things. It means it was created not required created in a way not required by statute. You still have judicial review, tax laws, and fraud laws that apply. If you're paying house taxes, you're paying property taxes, you pay your taxes on or registration for your vehicle, you still have to do those things. So the law will apply. You are just like any other entity. You're just shielding who actually owns it, or who's actually in charge of it. And then when you pass, you can quickly and easily hand over the reins to your property to the next of kin. So uh, a revocable trust is a trust where the settlor, which is us in this case in the CYC, when we create a revocable living trust, we can add property into it. We can put our house, we can put our car in the trust. We can also revoke, we can take out the house. If I want to sell it, I can take the house out of the trust and I can sell it because I have that power. Now, I put it in there because it's so much easier for probate. When I pass, my children will then the very next day take over and still have full access to the house. All that will go outside the wills and probate in courts. My friend here has his mother passed. She had $1,400 in her bank account. He had to pay $200-300 and had 6-7 months in probate court to get that $1,400. All that is avoided when you have a trust. The properties, of course, a revocable living trust, once you pass, becomes an irrevocable and you're handed over the property to the next of kin or to the beneficiaries. Now, the weakness you have here is that a revocable living trust does not protect you from legal matters. So if you have a car in a revocable trust and you have an accident, they can pierce that trust and take everything that's in it. So you have to be careful with where you put your vehicles. Anne LaFleur, I know she said never put a vehicle in a trust, or especially not that trust, the trust where you have everything else in it. Now, an irrevocable trust is where you surrender your power and you cannot tell them what to do anymore. You will set up rules in your irrevocable trust that says, I want you to manage this property. Every 5 years, you will buy a new vehicle. Every, make sure that these houses are up and managed, taken care of, and you use that for asset protection and tax planning. You can see what your taxes are going to be and how you can strategically remove taxes from your as you plan down the line. But it doesn't mean you're untouchable. Yeah. Now the power here is that you have as a revocable, you have the power as yourself, but that control comes with risk. Now, once you give up your power, when you surrender that power to a group of trustees or a different trustee, that independence is your protection. So you might drive the car and there's an accident, and they're going to say, well, we're going to take everything you own. Oh, good. I own nothing. I own nothing. Everything's owned by my trust. You can take these clothes off my back if you want, but there's nothing here for you to take. So that's the protection you get with putting your assets in a trust. So how do trusts fail? It doesn't fail because you scribbled something wrong on a paper. We're sometimes worried about what is the exact wordage I need to have for this trust to work, to be bulletproof. It fails in how you work it. If you're commingling your money, for example, if you use your personal checks and your to pay for some trust bills, or you use trust money to pay for your personal bills, that trust will be pierced because the court will say when things happen, the court will say, well, here clearly you don't understand the difference, the independence that the trustee has. There's no independence here. And the same with a puppet trustee. Are you controlling that independent trustee? Is it just a buddy of yours? And you tell them, okay, hey, just do this for me, or do this. Make sure you sell this house. We're going to buy another one down the street. It'll be much cooler. No, you can't do that. And then you have circular transactions where you're moving money around to make money. You might have a friend that has an investment firm, and he gets 2% every time you make a purchase through the trust, or every time you move money into that money market account or something like that. And then he gives you a piece of that. And then that money you take and you have assets that you don't want to transfer into. You buy and you transfer assets in. You're mixing money around. You're moving around money, which the court will see. The court will eventually go through, in the case of a lawsuit, courts will go through all of your funds and go, what is this? What is it you're doing here? When they see this, your trust will fail. There's no protection here. They will cancel this trust on you immediately. And of course, if you have no separation at all, if you're just signing as yourself on everything for a revocable trust, or if your brother is your irrevocable trustee, there's no separation of control there. My brother and I live together, we're roommates, and that's not going to work. The courts will destroy that trust every time. So the real power for trusts come from having the proper structure. You have the trustee versus the beneficiary and the asset, right? You have an honest administration. an independent trusteeship, and then the respect for the fiduciary duty. Got to make sure that the money's paid on time, got to make sure that the bills are paid on time. If you have today a mortgage and you pay them your taxes also with the mortgage, they are responsible to make sure that those taxes are paid on time. And they do. They have a whole firm that makes sure that you pay your state taxes, your property taxes, and that kind of stuff on time. That they're supposed to. But if they don't do it, and then you get hit with a fine because you didn't pay it on time, and then they come back to you and say, "Hey, you need to pay more money here." No, I'm not. That's not fiduciary duty. You can sue them for that. So you need to have these four things. So remember, you need to operate like a trustee, not a theorist. No paper shield is stronger than honest administration. And education is your real protection. And that, ladies and gentlemen, is how we operate in trusts.